Right, so in this case reading video, we're going to be looking at the Carr and J.A. Berriman case, which deals with a range of different principles that are relevant to termination for breach of contract. The case is in the context of repudiation, but in the context of repudiation, it looks at the effect of a delay of time on performance and whether that constitutes or can constitute repudiation. Also, the nature of time stipulations generally and how something can be made to be of the essence. It also looks at the loss of the right to terminate in instances of election. And this case also looks at the effect of cumulative breaches. So when you have more than one breach, how I guess the courts can see those two things together as, you know, both providing evidence of repudiation. So in this case, we were dealing with a contract for Berriman to erect a factory on Carr's land. Now, as part of the contract, Carr was to clear the land by a certain date, which you find out it didn't occur. And also, Berriman was to supply steel. So steel was meant to be fabricated as part of the building of this factory. Now, Carr failed to clear the land by the due date. The land itself was covered in heavy machinery, so, you know, Berriman couldn't begin erecting the factory, although I believe as well the architect who was to design the plans and give Berriman the specifications also hadn't done that, so there was no way they were getting onto the land to build the factory. Also, part of the reason why the land hadn't been cleared was due to heavy weather. Berriman, in the meantime, had accepted tender for the supply of steel, and Carr knew this. So Carr knew that Berriman were continuing on with their side of the contract. Carr then entered into a contract for the supply of steel with a different supplier, with Arcos. So here you had two breaches of contract at the heart of the case. You had the failure to clear the land, and you had the decision to contract with the other supplier in breach of contract. Now, Berriman notified Carr that they were terminating the agreement as a result of these breaches. In the termination letter, they actually stated they were terminating pursuant to a clause in the written contract, but yeah, that wasn't pleaded at trial. The termination wasn't in accordance with the clause at all. The right to terminate arose at law. Okay. Then Berriman claimed damages for the breach because they were ultimately liable for the person that paid, contracted with for the supply of the steel for the building, which never eventuated. So they claimed damages for the breach as well as that termination. And then Carr then claimed damages for breach of contract as well. Okay. Whew. All right. So ultimately, it was held, I think actually, yeah, my slide repeats the same thing. Sorry. So ultimately, it was held that the contract had been breached by Carr. Okay. So with regards to the failure to clear the land, Justice Fulliger criticised the reasoning of the lower courts. So the failure to clear the land was seen by the lower courts as a breach justifying termination. Here, the completion of the clearing of the land was not a condition. And so because of that, what was meant was that Berriman had to have issued a notice to complete for the time of completion to be seen to be of the essence for that breach to then give rise to a right to terminate. However, here they didn't issue a notice to complete. The court then looked at the second breach, which was the decision to enter into the contract with the supplier. And Justice Fulliger took a very dim view of this conduct, given that it was a deliberate and flagrant breach of the duties under the contract. And it also went to a very substantial part of the contract. I think it was something like the profit of a quarter of the whole contract was bound up in the supply of this fabricated steel. Because of the nature of that breach, the court saw it as evidence of that unwillingness to perform the contract that amounted to repudiation. Now, in terms of coming up with that that interpretation of the breach around the going with the separate supplier for the steel, Justice Fulliger didn't disregard that first breach of the failure to clear the land. So he saw that the failure to clear the land didn't of itself give rise to a right to terminate, but it could be considered as part of, I guess, the background facts around whether repudiation existed here. So it was seen as part of that consideration of the unwillingness to carry out, for Carr to carry out their side of the bargain. So two breaches can cumulatively give rise to the right to terminate. Okay. One other thing of the reasoning that I wanted to mention, is that Berriman didn't give that notice to complete, to turn that delay in performance into a condition that would then justify, if they continued to fail to complete the clearing of the land, that would then justify that right to terminate. In addition to not doing the notice to complete, the conduct of Berriman was seen to be consistent with the continuation of the contract. So it was said by the court that, you know, even if they had have issued the notice to complete, their behaviour was inconsistent with an election to terminate. So they would have actually lost the right to terminate. All right. So here, Berriman wrote to Carr's agent purporting to cancel the contract, so purporting to terminate it. And Berriman asserted that clause 20 of the contract gave him the right to cancel. Was this correct? No, it wasn't. I don't actually have the details on what clause 20 said, but in the judgment, it states that clause 20 didn't actually apply here. It wasn't relevant, and that the right to terminate was a right that arose at law. Okay. Right. In terms of the second question, so two separate breaches by Carr were alleged by Berriman. What were they? So it was the failure to prepare the site, as well as the making of an arrangement with the alternate steel supplier with Arcos products. The third question, so the contract stipulated that the building site was to be excavated and given over to the builder on the 29th of May. Was the site ready? No, it was not. Okay, so there's one of those breaches of contract, but here breach of a warranty, because the time was not an essential term. Okay, it's just a breach of warranty, so it gives rise to damages, but not the right to terminate unless a notice to complete has been issued and then not complied with. In terms of the next question, Justice Fulliger clearly state whether Berriman might have terminated that day. No, not directly, but that idea of timing being of the essence is relevant here. And here time wasn't of the essence, therefore that notice to complete was required to be issued by Berriman, which it wasn't. Where a party to a contract is required to do something by a certain date, the time to carry out that particular obligation will be of the essence or not, and you just look to the terms of the contract to see whether it's an essential term, time of the essence or not. And that depends obviously on the court's interpretation of the importance of the party complying on time. So unless specified by the parties, time will not normally be of the essence. So it'll literally state in the contract, time is of the essence. So it's where the time is not deemed to be of the essence, the party wronged must first serve a notice to complete on the other side, requesting compliance to complete the task within a reasonable time, and notify them that otherwise they will terminate the contract and seek damages. Okay, so where time is of the essence, so it specifically states that in the contract, no notice is required to be given, because it'll be a breach of a condition if the person fails to do what they're supposed to do on time. So you only need the notice to complete if the time is a warranty, not a condition. Next question, so what problem did Justice Fulliger identify in relation to Berriman's asserted right to terminate on the ground alone that the site was not ready on the 29th of May? Time was not of the essence here, therefore they were required to serve a notice and they didn't. Okay. Also, Berriman only did acts consistent with the continued existence of the contract. So even if they had had a right to terminate, it would be seen to be they would have been seen to have affirmed the contract here. And in terms of those acts that show that it was inconsistent with the that shows their acts were consistent with the continued continuance of the contract, they engaged the steel fabricators, for example, to do the necessary work. So they continued to do the things they needed to do to perform their obligations under the contract. So that shows evidence of affirmation. Why did Carr's action in giving a steel fabrication contract to Arcos Products alone justify rescission? This is because it was seen to be a repudiation here. So repudiation, just going back over the general principles, repudiation is conduct evidencing an intention or unwillingness, or an inability to render substantial performance of the contract. Okay. Now here, giving a steel fabrication contract to somebody else, to Arcos, it was deemed to be a deliberate breach of a very substantial part of the contract. So within that overarching evidence showing repudiation. Now, the reason why it was seen to be a substantial part of the contract is because the estimated profit lost by the breach was about 1/4 of the total estimated profit on the contract. Okay. Finally, can the effect of separate breaches be cumulative? So here, this question is interesting because obviously you've got the two breaches. You've got the first breach around time, and then even if they had the right to terminate, they've then acted inconsistently with that right to terminate by affirming the contract. And then you've got the next breach, which was the giving the tender for the steel to someone else. So the question is, if somebody has breached the contract, has a right to terminate, then affirms the contract, can that initial breach be seen to be part of, I guess, the argument around whether that second breach amounts to repudiation or not? Okay, so whether that first breach comes back into play despite the fact that a contract has been affirmed. And here the court said it certainly can be cumulative, the two breaches. So even if affirmation takes place, the first breach can still be relevant to whether the second breach or the contract as a whole has been repudiated. And you can see that at 351 of the judgment. The court states that an election not to rescind for failure to deliver the excavated site on the due date could not deprive that failure of all its significance. When a second breach occurs, the two combined may have significance, which it might not be legitimate to attach to the first alone. All right, thank you.